Good evening, it's now 1:03am. It was Sunday night, the 9th of October 2016, now into Monday morning, the 10th of October 2016. I do need to go home soon and get some rest. I've got to go to court in the morning, but I have had a request to again explain the issues on appeal in relation to this case. So the central question that requires determination is whether fishing crew employed on a foreign fishing vessel in New Zealand by an employer who was in ownership of that vessel, which became forfeited to the Crown for fishing crimes, whether those fishermen can claim an interest in a sister ship as other forfeit property under section 256 (1) C of the Fisheries Act 1996 to claim relief from the effects of forfeiture to obtain their unpaid wages. Okay, so just breaking it down, you have to be a fishing crew to claim your wages under section 256 of the Fisheries Act. They're the only people who can claim wages, and they have to be a particular kind. They have to have worked on a foreign vessel. So if you worked on a vessel that wasn't a foreign vessel, you cannot claim under section 256. The vessel also must be forfeited for a fishing crime. Okay, so the vessels get forfeited when certain sections of the Fisheries Act are violated. That's very, very bad criminal offending has taken place, and the vessels get forfeited. You will know that from traffic law that if you do, for example, 2 drink drives within a 4-year period, the court can confiscate your motor vehicle. Well, under this law, it's quite mandatory. You do a certain type of fishing crime, you lose the vessel. Then you'd have to make a special reasons argument to not be forfeited, or you have to apply for relief from forfeiture. So the criminal owner of this company has applied for relief from forfeiture, but so have the innocent workers who worked on their vessels. And just going over it all again, one vessel sank, Oyang 70. So we have Mr. Hartenow, Mr. Wyono, and number 28 and number 29. Actually, number 29, maybe number 30, who worked on Oyang 70, who can't get any wages because their vessel sunk and their employer is unwilling to pay them. Why? They're basically just a criminal corporation, I think, in my view, that make profits out of fishing and have violated the Minimum Wages Act. And I'm prepared to say that because I have proof of it. So it's not defamation, it's the truth. And there is an overwhelming sense of evidence about it. I filed affidavits about it and I've got the bank statements. Okay, so they didn't get paid the minimum wage. While the fact that these are Indonesian people working in New Zealand, that's because they've come in on a work permit. Why have they come in on a work permit? It's because there's not enough New Zealand fishermen willing to fish quota fish. What's a quota fish? Well, in New Zealand they say you can only fish so many fish, and they give fishing vessels a quota of how much they're allowed to catch. And we haven't got enough fishing vessels in New Zealand either, so foreign vessels come in to do the fishing to get the quota fish. Stocked with third world people. Why? Because we haven't got enough fishermen and nobody wants to work in disgusting conditions. And are they disgusting? Yes. Okay, that's the safety equipment. A plastic bag over your head? I think not. That's the bedroom. You know, yuck. More yuck? That's the bathroom. That's a toilet for 30 people to use. My crew members recognise that toilet from Oyang 77. Right, do you want to work like that? I don't think so. But these poor people got stuck on this vessel, as we've explained, over and over and over again, in terrible conditions, and they were abused. Some were raped, assaulted, verbally abused. And the ones that weren't raped or assaulted watched it, saw it, knew it was going on, and just felt trapped in the whole situation of being on this ship in New Zealand, catching the fish on their 2-year contracts. Why? Because they put up security. What security? Well, they had to put up their mother's house or the paddy field, anything they've got, even if it's a vehicle. They had wages withheld from them, and they're only on contracts of $200 a month to $220 to $290 a month. Those wages were withheld for the first 3 months up to the first 5 months. Furthermore, some fishermen had up to 30% of those wages that they were due for the balance of their 2-year contract at $200 a month to $220 to $290 a month, withheld for the balance of their contract. So if they absconded when the vessel came into port to unload all this fish, they would not have got those wages or anything else. They'd have to pay for their air tickets home, and they're just too poor to do all that. And if they put up security of their mother's house or paddy field and then they went home like that, then they'd all be made destitute and homeless and even in more poverty when they started. All in all, I'm submitting that's unpaid wages. They didn't get paid, they were exploited, and it crossed the line from voluntary employment and became forced labour. No matter what you say, it's totally unacceptable. So my job is to get these people paid. Why did I take on this job? I don't know. They asked for help. Nobody would help them, and they had to have an instructing solicitor. That is a solicitor who runs a law firm who has a trust account. From there they could brief a barrister if they wanted to. But I'm a person that runs a law firm, and I have a trust account, and I have litigation experience. Therefore, I ended up becoming their lawyer. And to do that, I had to go to Indonesia, where I took their instructions. They waited 5 years to find someone who would help them, and that person was me. And I've been working on it for over 18 months trying to get them paid. We're up to a Court of Appeal hearing. We were successful in the High Court to get the High Court to agree that they could be paid wages out of a forfeited sister ship, that being a 95 vessel, Oyang 95. Oyang 75, that's worth about $8 million, which would be sufficient to pay all the wages. But we've got all these obstacles in our path. The Crown, via the Ministry of Primary Industries, which is basically New Zealand's fishing department, is saying, oh no, you can't apply over the sister ship. That means they just want to keep it. And they've sort of got the position to say, oh, well, we don't sort of mind if you claimed over, as long as you could, prove you have an interest. But you can only have an interest if you have previously arrested the vessel in Ream before it got forfeited. And of course, the Sajo Oyang Corporation just wants to put every obstacle in the block up there, and they're saying, well, yes, you have to have arrested the vessel first, gone to the Admiralty Court first, and had your wages determined first before the vessel got forfeited. But the Section 256 of the Fisheries Act was popped in there in a 2002 amendment, specially designed to protect foreign fishermen and to ensure that the foreign owner of the vessel was known to be the employer, and that they were supposed to be and guaranteed to be paid the minimum wage per hour for every hour they worked. And then they are allowed to apply to get their wages under Section 256 if the vessels have been forfeited. Before that amendment, they couldn't do that. When vessels were forfeited, it was the Minister of the Fishing Department, at the government, who decided what would happen to the forfeited vessels. Now there's a process where you can go to court under Section 256 of the Fisheries Act and ask a district court judge who forfeited the court in the first place for the fishing crimes whether you can get relief from forfeiture. And so we need to get access to Oyang 75. That means we need the Crown to back off and support us, because it's wrong. Chase the prosecutor all round Christchurch telling him that he just really can't have this vessel because it's wrong, and he should protect the innocent workers. Now, many of these workers from Oyang 75 gave evidence at the trial to prove the fishing crimes, but they've never followed up to make sure these people get paid, because really the government's all talk, aren't it? They changed the laws so that they could have protection. But right now, this is the first case and the only case we've had for foreign workers seeking to be paid under Oyang 75. And it's taken 18 months to get a court date in the Court of Appeal to argue about subsection 1 of 256. And what is subsection 1 about? It's a definitional section about who can apply for relief from forfeiture. Who can apply, and then over what? How hard can that be, people? If you've been paying attention to what I'm saying in my submissions, we're actually having a legal argument over the word other. Other. We've also had a previous appeal over the word the. The vessel that committed the crime, the. Or another one we had was other court. Sajo Oyang Corporation was saying, you must go to the other court, which must be some other place, but not the forfeiture court. And what I'm saying is that Section 256 is really quite a wonderful process. It was passed by Parliament to try to be bloody helpful in this situation, really, to create a streamlined little procedure. And it's great procedure if it would just logically work and people would stop fighting me over it. Okay, so the procedure should be that you stroll along to the forfeiture court and say, "Excuse me, Judge, before you dispose of these forfeited vessels, I've got outstanding wages. Look, this is my bank statement, this is my pay slip. I only got $200. I worked really hard, 20 hours a day, 7 days a week, all month doing this. Please pay me." And you might say, "Oh, by the way, I worked on a 2-year contract, so actually you've got to pay me for 2 years. Please pay me." And they just have to come up. They should just be able to fill out some forms, file an affidavit, put some proof in, go through the process and let the court determine the wages. And if it looks like they haven't been paid, then the vessel should be able to be sold to pay their wages. It should not require multi-jurisdictional litigation, which is what the Sajo Oyang Corporation wants these fishermen to do. Somehow they should all magically have lawyers that want to spend their life savings on it, to take them from a nice trip around the Employment Relations Authority, the Employment Court, the Court of Appeal and the Supreme Court, while also going for a nice little trip around the Admiralty Court and the Court of Appeal and the Supreme Court into relation to that, and a little trip around the Forfeiture Court, then the High Court on Appeal, the Court of Appeal and the Supreme Court. Plus, if you did an in personam claim, and you got your judges to award you wages, you couldn't even get them in New Zealand because the vessels are forfeited. The Sajo Oyang Corporation doesn't have any offices in New Zealand. The New Zealand charter partner, this Southern Storm Fishing 2007 Limited, conveniently, struck themselves off the company register within a few months of me filing a claim, so that they don't have to pay under a guarantee to pay the wages. So there is no way to enforce a claim for wages in New Zealand unless you get the wages paid out of the forfeited vessel. So why all this mucking around New Zealand? Why is the Ministry of Primary Industries hanging on to an $8 million vessel? What are they going to do with all that money? Just investigate a few more crimes with it? Well, they told me they only care about fish. Well, we need them to care about the crew. Why do we need them to care about the crew? Because there was human rights abuses here, and breaches of the Minimum Wage Act is also not acceptable. It's not acceptable to rape, abuse people on the ship, and it's not acceptable not to pay them. They're guaranteed the minimum wage, and we should ensure New Zealand's problems get mopped up here in New Zealand and they actually get paid. And they need to get paid out of the forfeited vessel. It's the only trusted source of money. They will never get paid otherwise. What is New Zealand doing? Have we got parliamentarians just talking up air in Parliament, passing laws that don't give any effect in the courts? The judges are trying really hard. And there's just a lot of mucking around over the word other. So that's the issue. Should the fishermen who worked very hard in New Zealand on a New Zealand work permit get paid the minimum wage? Well, funnily enough, they should. Why? Because it says so in the statute. Minimum Wages Act 1983 and Section 103 of the Fisheries Act. It also says it everywhere in the Code of Conduct 2006. We have a means to pay them this wages. We can pay it out of the vessel. There's no reason for the Ministry of Primary Industries to keep it. I would like an explanation for the Minister of Primary Industries as to why they are oppositioning to me and why they won't get their act together to help us. I find it unacceptable. I also would like a criminal investigation into these allegations, and I can provide evidence. We have affidavits, and in fact, if you'd like to go to the Crown Solicitor's office in Christchurch, you will find, several kgs, maybe 10 kgs worth of files I sent to him as part of our court case on oath. And should you like the bank statements, I've got them. I could probably give you about 23 kgs of evidence on it. Altogether, I filed about 61 kgs between them and all the different counsel involved. We are rolling in evidence, we are rolling in injustice, and what we want, New Zealand, is justice. Are we going to get it? Yes, we are, because we will persist until we get it, because this is unacceptable, and we will not accept anything less than justice. What is justice? To be paid the full legal entitlements for what they have earned, and we're entitled to under the New Zealand Minimum Wages Act, the 2006 Code of Conduct, for the top-up rate per hour, holiday pay. They'd also like an apology, and their counsel should also be paid as well, their full costs. Anything else is repugnant to justice.